Hello, y'all. This is Minister Dominic Alexander. Come here, Taylor, so you can sit right here. Minister Dominic Alexander, president and founder of the Next Generation Action Network. Um, the Next Generation Action Network is one of three organizations representing Crystal. Today I'm here with Crystal Mason and her general counsel, Kim T. Cole, as well as her daughter, who is present. Also note that the ACLU and the Texas Civil Rights Project is the other two organizations representing. Today what we saw.
Sorry, can you say and spell your first and last name so we get it right?
Okay, perfect. DOMINIQUEALEXANDER. We first off want to say thank you to Commissioner Simmons for her leadership in making sure that we give a voice towards tax dollars being wasted, right? What we saw from the Tarrant County District Attorney today was just unjust and literally just a miscarriage of justice in every different form of fashion. The district attorney's basically testimony in front of the commissioner's court was very misleading. It left out the biggest part that both appeals court literally said in their decision in order to basically overturn the case that eventually was overturned, that was recommended back to the district court. One of the biggest things since the first day we got Crystal's case is that they literally, their whole defense is that Crystal did not need to know that she didn't have the right to vote. She didn't know, basically saying that Crystal didn't have to know that she was committing a crime. That was the whole basis of their whole prosecution, right? When we went in front of the Tarrant County Appeals Court the first time, they said she didn't need to know. That appeals court literally agreed with them. Then we went to the highest court in the state of Texas, and the Texas Criminal Court of Appeals came back and said that Crystal Mason had to know that she was not eligible to vote. That means Crystal Mason had to know that she was committing a crime. That literally threw out the whole basis of the conviction that Tarrant County even got in the district court. But you literally heard a Tarrant County district attorney literally go before the commissioner's court as if the appeals court never gave a ruling, never gave a position, and never even said why they recommended it back to the district court and vacated the conviction. That was literally misleading and literally an outright lie in front of the taxpayers and the county judge. And so that's the reason why NGAN and the ACLU and Texas Civil Rights Project literally is committed towards this case and making sure that we put out the facts that is in this case. Now, the Tarrant County District Attorney Office is now going to the Texas Appeal Courts, asking the Texas Appeal Court to reconsider what they have already said. But he literally said, as if they did not put any facts or that they didn't even look at the facts. The Texas Criminal Court of Appeals and the Tarrant County Criminal Court of Appeals literally looked at all of the facts and laws. And so, of course, I will allow the attorney to kind of speak onto it, because I know that Kim has been a part of this process for years in case briefings after case after showing up. And also, Kim was also present when Crystal literally was sentenced to 11 months in a federal prison for this case. When a federal judge, Judge McBride, said over the bench, she didn't have to know that she wasn't a legal vote, and he also stated, Lord rest his soul, literally stated that he told her that she couldn't vote or whatever. So I want people to understand what this mother has had to go through for these long years, and to see that the Tarrant County District Attorney is literally continuing this quest to prosecute Crystal Mason is just a level of injustice. So I'm going to pass it over to Kim T. Cole, who is the General Counsel of NGAN, also attorney for Crystal Mason.
Kim T. Cole, Kim, middle initial T, last name Cole. I wanted to set the record straight. The Tarrant County District Attorney was very disingenuous with his commentary regarding this case. The Second Court of Appeals returned Crystal's conviction and remanded it down and stated that the evidence was insufficient to support a finding of guilt. I understand he does not like the decision. I get it, because his predecessor, who originally prosecuted Crystal, specifically stated in his summation of Crystal's criminal case that he wanted the judge to send a message to Tarrant County voters. And the current district attorney is doubling down on sending that message. What he failed to mention to the taxpayers here is that this case has been going on for 7 years. Crystal voted in 2016. They have been prosecuting her for years. So this isn't, oh, one person wrote a brief. This case has been tried, it has been appealed again, it has been sent back down, it is being appealed again. So this is not something that just cost pennies and one person to do. What he also failed to mention, he misquoted the court record. Like I said, the Second Court of Appeals said that the evidence was insufficient. Let me tell you why the evidence was insufficient, okay? Their own witnesses, the county's own witness, the county brought in election officials, and they had sent letters to Crystal when she went to jail for her federal charge. They had sent letters to her home while she was in federal prison. Well, Crystal spent over 3 years in federal prison. So clearly she did not get those letters. They sent the letters to her home. So that was the county's witness to prove that Crystal knew, look, we sent you letters. Well, she wasn't residing at that address. She was in the custody of the United States Bureau of Prisons at that time. So she never got those letters. That was one of their witnesses. Another witness was with the Federal Bureau of Prisons. He is the supervisor over the probation division, Kenneth Mays. He got on the stand. This is a state witness. This is someone that the Tarrant County District Attorney's Office presented. They asked him point blank, didn't you tell Crystal Mason she wasn't able to vote? His response was no. No, he never told her, period. And those are the facts that the current district attorney obviously has conveniently left out. The Second Court of Appeals recognized their error. When they upheld the conviction originally, they said it didn't matter whether she knew that she was eligible to vote or not. That's not what the law says. The law actually says that a person commits the offense if they know that they are not eligible. So, in any regard, so the Second Court of Appeals recognized their error from the first time they upheld the conviction and made the right decision this time after being corrected by the Court of Criminal Appeals. Obviously, the Court of Criminal Appeals said she has to know, so go back, look at the evidence, and see whether the evidence presented at trial was sufficient, even in viewing it in the light most favorable to the conviction. You can't ignore the facts. Crystal did not know, and also he misquoted Crystal. When she was on the stand during her trial, they asked her, did you read this? You know, you're reading the provisional ballot, you know, don't you understand that you can't vote? And her response was, I do now. After being put on trial, yes, I understand it. That was her response. I do now. It wasn't I do. It was I do now. And he conveniently left that part out. He is being dishonest with Tarrant County taxpayers. Obviously, today we heard very distraught citizens of Tarrant County who have had loved ones die in the custody of Tarrant County officials. We have heard members of the community outraged about lack of mental health resources here in Tarrant County. Tarrant County money should be better spent than pushing a political narrative. That is what the Tarrant County District Attorney is doing in continuing to persecute, not prosecute, to persecute Ms. Mason. In their original trial, they stated they wanted to send a message, and he doubled down on it in his announcement that they were appealing this decision. Once again, he referenced sending a message. This is a political narrative that should not be funded by Tarrant County taxpayers.
We'll open up for questions now.
Can we hear a little bit from Crystal? We talked to you a few weeks ago, and you were so overjoyed to the point of tears that you could finally move on with your life. How are you feeling now?
First of all, I'm frustrated, I'm mad, I'm upset. I'm upset on the things that I heard the DA say. And like he said, he's only been here for a year and a half, so what is his motive to continue this case if he wasn't here from the beginning? And that's one thing, to send a message to scare voters from the poll. And that's exactly what he's doing by continuing to try to prosecute this case. I filled out a provisional ballot.
When he was addressing, oh, go ahead, I'm sorry.
I filled out a provisional ballot that was never counted. I went to the same polling place that I went to in 2006 and 12. I went to the same polling place. I've been in my house since '08. Where is my intentions to commit a crime? I thought I was eligible to vote. I finished my time in feds. I was on something called supervised release where I only reported on the internet. So my supervised release supervisor, Kenneth Mays, testified on the stand, not for me, for the state, and said, no, we never told her. No, she never signed anything. When you're on supervisor, or when you're on probation, parole, whatever, you have terms and conditions. Nowhere on my terms and conditions told me I was ineligible to vote. Who goes and commit a crime and intentionally want to go to jail when you just got out rehabilitating yourself back into this world? You know, leaving your kids. I don't know, I'm a mother. I'm a nourisher, you know, the hardest thing for me. I'm not gonna say I'm not perfect, okay? I do have a criminal record, okay? I'm gonna say that. But to leave my kids, I ain't never did that. So when I came out running. I came out letting them know that, hey, your mom hit this bump in the road, but look at her. I came out a certified paralegal. That means I paid for classes in prison. I came out working at the bank, Santander, insurance for my kids. So who goes to the polling place to commit a crime to say, I'm gonna leave you again? No, not at all. Matter of fact, Kenneth Mays said on the stand, there's nothing in place to even let us know that we're ineligible or eligible to vote. So how was I supposed to know? This is overwhelming, this is sickening, and I'm so glad that I have the community here supporting this and seeing this. And that's where I'm at. I really don't want to answer no more questions. I'm frustrated and I'm just overwhelmed.
Okay, let's direct our questions towards Kim and myself, and then we'll go from there. Any questions? Any questions? No questions? No whatsoever. Thank you so much.
Thank you.
Thank you.